That's your name, ma'am?
Yes.
Okay. Do you have an attorney?
No.
Okay. We'll get you on Zoom so you can meet with Mr. Cyber and see if you can come to a resolution. Otherwise, we can proceed with the hearing today, okay? They just want an adjournment?
Judge, my client would like to have this matter adjourned until May, the first week in May. I believe the parties together have worked it out, and we should be able to dismiss in May.
May 10th at 2:45.
Thank you.
Put your notice to appear, okay?
Thank you.
You're welcome. Okay, what's your name?
Have a good day, ma'am.
I'm sorry? And Ms. Tell is representing you, correct? Okay, Mr. Cyber, is that all that you have? You might be closing. Yeah, someone at 3:30 actually. Where's the 1:30 people? No.
I'm sorry. Break down.
Good afternoon. What's your name, ma'am?
I'm sorry, are you talking to me?
Yes, ma'am. What's your name?
Jessica Gilbert.
Oh, good afternoon, Mr. Fleeman.
Good afternoon. How are you?
I'm well, thank you.
Good.
Let's see, are we ready on the matter with the Kings?
We are, yes.
Okay, we're on the record in the matter of Waverly Lansing LDHA versus Danny King and RF King, file number 22-03875 LT, counsel appearance.
Tyrone Fleeman on behalf of the plaintiff.
And Mr. and Ms. King, you can hear me clearly, correct?
Yes,
And you're proceeding without counsel today?
correct.
Okay, today was the date and time that was set for a hearing. You met privately with Mr. Fleeman, counsel for the plaintiff. Mr. Fleeman, did you all come to an agreement?
We did, Your Honor. We got to the realization that the rents owed are just going to be too much for the tenants to keep up with. So their intent is to vacate. I have prepared a DC 508 conditional dismissal form, and I crossed off the money portion and put in the further conditions. Defendant shall vacate and turn in keys by April 30th. I got authority to stretch that out to the 30th. Any money issues between the parties will be resolved in the normal course of business and pursuant to the Michigan Security Deposit Act. And I would ask the court if it's acceptable for me to sign the defendant's name by permission if they give their permission on the record. And if so, I can give it to the court and to them at the same time.
Okay, something's going on with your volume. At the end, it started to trail off a little bit. You asked for permission to sign their name with their consent, and then I lost you after that.
Okay. I don't remember where I went from there, but I'll pick up. Yeah, if it's okay with you that I sign their name by permission and it's okay with them, we've discussed already, then I would email it to you and to them at the same time as a signed version. It's just often difficult for people to attach an electric signature and get it back to me.
That makes sense. Okay, Mr. and Mrs. King, you understand or heard the terms of the arrangement that was stated on the record by Mr. Fleeman?
That is correct, Your Honor.
Okay, so you're both agreeing to vacate the property by April 30th, and there's a conditional dismissal that you're agreeing to enter into with that stipulation?
Yes, ma'am.
Okay. And you understand that they can still pursue money damages or other recourse under the court law. You understand that, or the court rules?
That
You
is
understand
correct.
that? Okay, you understand that you have the right to be represented by an attorney today?
Yes,
You also have the right to proceed to a trial if you had demanded a trial, or you could have proceeded to hearing today. That's the purpose of today's court date. So you have the right to have a hearing. And you want to waive those rights today, both the right to a attorney and the right to a hearing?
correct.
Okay, is anybody threatening you or making any promises to you to get you to waive your right?
Not at all.
Okay, and do you give Mr. Fleeman permission to sign your name to the conditional dismissal?
Yes,
Okay, do you have any questions at this time?
not at this time.
You You have 3 business days to return to the court. If you leave here today and you determine that you misunderstood any of the rights that you just waived in order to enter into this agreement, you can return to the court and request to have the agreement set aside, and we'll set it for a hearing. Understand that partial or performance will not satisfy the conditional dismissal. So that means if your agreement is to vacate by April 30th, you need to leave the property and take all of your belongings by then. You understand that?
Yes, ma'am.
Very good. Any additional matters for the record, counsel?
Nothing further on this one, Your Honor. Thank you.
Thank you. You're all set, Mr. and Mrs. King. Thank you.
Oh, wait a minute, Judge. I do want to verify. You want me to email that to Judge Simmons courtroom at lansingmi.gov, or do you want me to send that to the clerk?
Judge Simmons courtroom at lansingmi.gov.
I will send it to that one. Thank you very much, and you have a good day now.
Same to you. Joe Joseph. And Ms. Gilbert, you didn't have an attorney, correct? You're muted, ma'am.
I'm sorry, I don't.
Okay, and have you already met with our eviction diversion facilitator, or did you want to do so at this time?
I think I met with a young lady last time, I believe so, when I was last here.
Okay, well, that would not have been our eviction diversion facilitator. Mr. Rosa, who's present here, is our eviction diversion facilitator. And it's
Okay,
up to you if you'd like to meet with him and see if there are any resources that you could benefit from it during this time. You can do that at this time before you proceed with your hearing.
yeah, I would like to see what resources are available to me.
Okay, give me just a moment. I'll put you in the room with Mr. Rosa.
Thank you.
Thank you.
Are we adjourning this, Judge, or just she's gonna come back?
She's gonna come back.
Oh, okay. All right, thanks.
No problem. Oh, people are crazy. This lady killed her daughters in a plot to get revenge on her husband.
What?
You heard me. Trust no one. Okay? Who can you trust? If your mom will kill you, give you a sleeping pill, and then shoot you in the head while you're sleeping.
Your own mom?
Your own mom to get revenge on her husband. And she didn't even get life in prison, by the way. She only got 78 years. That was in Virginia. Hello. How are you?
Good. Checking in. Woodbridge versus Shoemaker. Free. Okay, I'll talk to him real quick. Come back in. Is that okay, Judge? Can I speak with them in the hallway?
Yeah, they have an attorney.
Oh, they have an attorney.
She's on
Okay.
Zoom. Do you have access to Zoom or your phone with you?
I do.
Yeah, if you get on Zoom, you can talk to Ms. Till.
Okay.
Ms. Till, do you need your clients to be on Zoom as well?
Yes, if we could do that. I don't need them in the breakout room for when I first speak to opposing counsel, but I will probably need to talk to them after speaking with counsel.
Okay, we'll get them set up right now as well.
All right, thank you so much. I appreciate it.
No problem.
Hi, Felicity.
Yes, hold on. I will join you in the breakout room.
Oh, I'm sorry. Okay.
I got a room break.
Oh, do you?
Thank you, Your Honor. I'm all set with Jessica.
Thank you, Mr. Rosa. Mr. Joseph? Okay.
Yes, Judge.
I'm gonna put you and Miss Gilbert in the room together.
Okay, sounds good.
Ms. Gilbert, if you can return to room 1,
How do I go to room 1? I don't know.
you should see a breakout room tab on your,
Oh, okay. Yep, I see it here. Okay, thanks.
no problem.
Your Honor, if I could be placed in a breakout room with Ms. Schumacher and Mr. Stillman. Thank you.
Mr. Joseph,
Yes, sir.
were you able to meet with Ms. Gilbert?
Yep, we're also, we just need an adjourn date, that's all.
How much time do you need?
Judge, I just need to verify with my client that she has tendered keys. She, according to Ms. Gilbert, she's already vacated. So as little as a week, frankly, whatever fits on the court's docket.
At a time, April 5th at 8:30. April 5th, at what time? 8:30. Right here? Yeah, that's enough. That's right. April 5th at 8:30.
Sounds good. Hopefully we'll have a dismissal in before that.
Thank you.
Thank you.
You're all set, Ms. Gilbert.
Thank you.
Okay, Ms. Tillett still meeting with compliance.
Just want to let you know, I spoke to the legal aid attorney.
Still, can you just speak to Mr. Mr. Asphalt again?
Yes, if I could, which breakout room do you want me to go into?
I'll move you to room 2.
Okay, perfect.
What's your name?
My name is LaRonda Bell.
You're represented by Legal Services?
Yes, ma'am.
Okay, sounds good. You just joined from the iPhone?
Yes.
What's your name?
Diamond Glasgow.
Do you have an attorney?
No.
Mr. Joseph, are you there? Okay. And Ms. Glasgow, did you meet with Ms. DeRosa, our eviction diversion facilitator, before?
I spoke with one gentleman and I've been down with COVID. So I think I was able to get a call from someone, but they left me a voicemail.
Okay, did you want to speak with our eviction diversion facilitator before you met with the plaintiff's attorney?
No, because he kind of explained to me that there really is kind of little help for like, because basically I have half of my payment that Waverly Park is asking for. I just need to get the other amount so I can pay them off.
Okay, sounds good. Mr. Joseph, are you there?
I am, Judge.
Okay, I'm gonna put Ms. Glasgow in the room with you.
Sounds good. Do you want me just to join the one I was previously in?
That's correct.
Okay.
What happened? I don't see her anymore. Did we lose her? We lost her.
Okay. Hello?
Yes, can I help you?
Yes, ma'am. Can you hear me, Your Honor?
I can hear you. I'm putting you on mute until I'm ready for your case, okay?
Oh, okay. Yes, ma'am. Yes, ma'am.
Mr. Joseph, I'm not sure what happened with Ms. Glasgow. I think she got disconnected. Hopefully she'll log back in.
Okay, thank you. I'll just hang out until she does.
Thank you.
Well, I think it is, do I see LaRonda Bell?
Yes, but she's represented by legal services.
Oh, okay. No problem.
Okay. Ms. Tell,
Yes, could I be switched to breakout room 3? I believe we're almost all set.
okay, 1 second.
Thank you.
You're all set. Mr. Joseph, We're on the record in the matter of Woodbridge Apartments versus Abigail Schumacher and Dylan Selman, file number 22-03884 LT. Council appearance.
Christopher Asphalt, 53129 for the plaintiff.
Felicity Till, P83961, appearing on behalf of the defendants Abigail Schumacher and Dylan Stillman.
Thank you. Same as the date and the time that was set for a hearing. And my understanding is that there is a conditional dismissal. And one of the attorneys put the terms on the record.
I will do so. Okay, Felicity?
Yes, that's just fine.
Okay, so currently there's rent due and owing of $4,870. The late fees have been waived. There's court costs of $155 for a total amount of $5,025. The defendant shall pay that amount or vacate the property within 10 days of today's date, which I believe will be April 11th. If they fail to do either one of those, then plaintiff can move to set aside the conditional dismissal without need for further court hearing under paragraph 4B, and a judgment of possession and an order of eviction could enter at that time.
Thank you, Mr. Till. That's a complete and accurate understanding of the conditional dismissal terms.
Yes, it is, Your Honor.
Okay. And the Schumacher, is it Stillman or Stillman?
Stillman.
Stillman, okay. And those terms that was just indicated by Mr. Asphalt, that's what you understand your agreement to be?
Yes, Your Honor.
Okay, can you speak up so that it can be picked up on the record? Thank you. Okay, and so you understand that you have the right to proceed to a hearing today? Do you want to give up that right in order to enter into this conditional dismissal?
Yes.
Okay, you understand that partial performance under this agreement will not satisfy the conditional dismissal, has to be full performance?
Yes, ma'am.
Okay, so you're agreeing to pay $4,870 plus a late fee of $155 within 10 days or vacate by that day,
Yes.
which is April 11th, correct? You have any questions? Okay, Ms. Till, are you gonna be executing that document to file with the court?
Yes, I will, Your Honor.
Okay. You have
Mr.
3 business days. Oh, 1 second. You have 3 business days from today. If you leave here and realize you misunderstood any of the rights that you are waiving in order to enter into this agreement, you would be able to come and request to have this agreement set aside. You'd have to articulate or explain to the court how it was that you misunderstood your rights, okay? Okay, and I'm assuming, Ms. Toe, you want to know if you have Mr. Asphalt's permission to sign?
You read my mind, Your Honor.
Yes, you do. I wouldn't mind if you emailed it to me though as well, just for my records.
I will go ahead and draft and email that over to you.
Thank you.
Okay, any additional matters for the record, counsel?
No.
Anything for you, Ms. Till?
Nothing further for defendant, Your Honor.
Thank you. You're all set. Thank you.
Thank you, Judge. Have a good day.
Same to you. Okay, let's see. Ms. Till, I do have LaRonda Bell present. Did you need to speak with Mr. Joseph?
Yes, I do, Your Honor.
Do you want me to go back to, what is it, breakout room 4?
I'm actually gonna move you to room 3.
Okay,
Thank you. Ms. Till, you're in room 3.
Perfect, thank you.
No problem. And you can default Ms. Glasgow because she did not return. Okay, I have a person identified as Zoom user. What's your name? Did you hear me?
Brandy Eaton, maybe? I don't know if you're talking to me.
Okay. I am. You're identified as Zoom user.
Oh. Yes,
Okay,
Brandy Eaton.
Okay, do you have an attorney, Ms. Eaton?
I do not.
Okay, let me get you in a private meeting room. Mr. Hopper, do you have an attorney? You're muted.
I do not.
Okay, so Ms. Eaton, today was the date up for a hearing for a termination of tenancy. And so, Mr. Hopper, you don't have a counsel and neither does she. I would put you both in a private meeting room so you can see if you can come to an agreement. It could be a conditional dismissal, it could be a consent judgment, or you can decide that there is no agreement and we can proceed with the hearing, okay?
Okay.
Okay.
Okay, good afternoon, Mr. Scheck.
Good afternoon, Your Honor.
I don't see anyone present at this time. Mr. Scheck, on behalf of Dunn Nugent.
Okay, Judge, my client's here and we're ready to proceed.
Okay, sounds good. Tori Blackman is here. Tori Blackman, do you have an attorney?
No, I don't, ma'am.
Okay, did you already meet with our eviction diversion facilitator?
Yes, ma'am.
Okay, I'll put you in a private meeting room with the plaintiff's attorney so you can see if you can come to a resolution on this, okay?
Okay.
Room 2. Mr. Scheck, you can submit a default. You'll send it to Judge Simmons' courtroom at lansingmi.gov.
All right, Judge, I'll do so straight away. Thank you very much for your time today, Your Honor. We appreciate your time.
Thank you. Have a good one.
You too.
Judge, we've come to an agreement.
We're on the record in the matter of Michael Hopper versus Brandy Eaton, file number 22-03972LT. Mr. Hopper is present via Zoom and so is Ms. Eaton. And you all have come to a resolution already?
Yes, ma'am.
Okay, what is the agreement?
I will be out of the premises in 10 days.
The default judgment.
Well, it's not a default because she's present, but it's be a consent judgment?
Yes, consent judgment.
Okay, so ma'am, you're agreeing to vacate the property this April 11th?
Yes.
On or before April 10th?
Yes.
Okay, you understand, ma'am, that you have the right to be represented by counsel during this eviction process?
Yes.
You're giving up that right in order to enter into this consent judgment?
Yes.
You also understand that you have the right to have a hearing in this matter. You're waiving your hearing today?
Yes.
Anybody threatening you to get you to waive your hearing?
No.
Okay, is any promises being made to you in exchange for you waiving your hearing?
No, ma'am.
Okay, you have 3 business days from today. If you leave here and you determine that you misunderstood any of the rights that you are waiving in order to enter into consent judgment, you can return to the court and request to have this judgment set aside. You would need to tell the court how it was that you misunderstood your rights, okay, ma'am?
Yes.
Okay, and now, Ms. Eaton, are you giving me permission to sign your name to this consent judgment?
Yes.
What about you, Mr. Harper? Do we have your permission to sign your name to the consent judgment?
Yes, Your Honor.
Oh, very good. Do you have any questions, Mr. Harper?
I do not. Thank you.
Ms. Eaton, do you have any questions?
No, ma'am.
Okay, if you don't vacate the property by the 10th, Mr. Harper can come and request a writ of execution and remove you and your property from the premises. You understand that?
Yes.
Okay. We'll get that executed and filed with the court. You'll receive a copy in the mail. You're all set.
Thank
Thank
you.
you very much.
You're welcome.
Mm,
Were you in the room with Tori Blackman?
I was. Did she accidentally leave?
Oh, yeah, she's back. Hold on.
Okay.
Ms. Blackman, can you hear us?
Yes, ma'am.
Okay, very good. We're on the record in the matter of Circle West Apartments versus Troy Blackman in file number 22-04049 LT. Appearance counsel.
Correct dates, P number 80641 on behalf of plaintiff.
Okay, and then Tori Blackman is present via Zoom without counsel. Ms. Blackman, you and counsel for the plaintiff have met privately in regard to this hearing for an eviction for non-payment of rent. Counsel, have you come to an agreement?
Yes, Your Honor, we've agreed to a consent judgment for the amount of rent owing of $3,655. We would add $654 for April 2023, for cost of $155, for a total of $4,464, payable or move out date of April 28th, 2023. No money judgment, and the parties waive the 56-day rule as to the writ. I explained her rights in the Mission Court rule, and she gave me permission to sign on her behalf.
Thank you. Can I get those amounts again?
Yes, rent owing through today's date of $3,655. April rent of $654. Court costs $155 for a total of $4,464.
Okay, Ms. Blackman, that's a complete and accurate understanding of what you're agreeing to?
Yes, ma'am.
Okay, so you want to waive your right to be represented by counsel in order to enter into a consent judgment, ma'am?
Yes, ma'am.
Okay, you have the right to have a hearing today. You want to waive your right to a hearing today in order to enter into consent judgment?
Yes, ma'am.
Are you sure? You look confused.
I might be confused.
Okay, so you had on your pretrial date, we advised you of many of your rights. One of those rights was to be represented by an attorney. You may or may not have met with legal services. I don't know if you did, but you had the right to hire an attorney if you didn't go with legal services or didn't get representation through legal services. But you appeared today without an attorney. So is it safe to say that you're waiving your right to be represented by an attorney today?
Yeah. Yes, ma'am.
Okay, so the other thing is that you had a right to have a trial in this. You could have demanded a trial once you were served the summons and complaint. You also were set for a hearing today, so you could proceed with the hearing today, meaning you're not going to consent to vacate the property and to pay this money. You want them to prove that you owe it, or you likely have some other defense as to why you didn't pay it. Are you waiving your right to have that hearing today?
Yes, ma'am.
Okay. Is anybody threatening you to get you to waive your hearing?
No, ma'am.
Any promises being made to you if you waive your hearing?
No, ma'am.
Okay, so you're making a freely and voluntarily decision to enter a consent judgment that is to pay $3,655 plus April rent of $654 plus court costs of $155 for a total of $4,464 on or before April 10th, or vacate the premises by that date?
Your Honor, it's April 28th.
April 28th, okay. April 28th or vacate by that date, is that correct?
Yes, ma'am.
Okay. You have 3 business days, ma'am, from to date. If you leave here and you determine that you misunderstood any of the rights that we just went over, you can return to court and ask to have this consent judgment set aside. You would need to explain how you misunderstood the rights that you waived in order to enter this agreement, okay?
Yes, ma'am.
Lastly, do we have your permission to sign the consent judgment on your behalf?
Yes, ma'am.
Okay, do you have any questions, ma'am?
No, no, ma'am.
Thank you, Mr. Dax. Any additional matters for the record?
No additional matters. Thank you, Your Honor. Have a wonderful day.
Thank you, same to you. You're all set, Ms. Blackman. Have a good day.
Thank you. You as well.
Mr. Joseph?
Yes, Judge.
Okay, Ms. Glasgow never returned. You can submit default judgment. And then for LaRonda Bell, are you all ready to proceed?
Yes, Judge, we are.
What happened to this bell? Did she leave? Okay, we're on the record in Edward Rose Associates versus LaRonda Bell, file number 22-03962 LT, counsel appearance.
Joe, plaintiff.
Felicity Till for the defendant.
Today was the date and time set for hearing for non-payment of rent. How are we proceeding, counsel?
Your Honor, we would like to request a 2-week adjournment in this case, we're working with Capital Area Housing Partnership. And so we're just requesting an adjournment to allow those applications to proceed.
Okay. April 12th at 2. April 12th at 2.
Okay, very good.
No problem. Any additional matters for the record?
Nothing further from plaintiff.
Nothing for defendant, Your Honor.
Thank you both.
Thank you.
Thank you.
Who's on the device identified as iPhone?
My phone for iPhone, my phone had overheated and died. I was just trying to get back with the eviction prevention for eviction.
I can't see your face. Oh, Miss Glasgow.
Yes.
Okay, you know what, Ms. Glasgow, we gotta reset your matter because the attorneys has gone at this point. You want to meet with
Okay.
our eviction diversion facilitator, you said?
I'm sorry, what was that again?
Are you asking to meet with Mr. Rosa, our eviction diversion facilitator?
Yes.
Okay, can someone message him and ask him about it? Add a slot for her. We're gonna reset your hearing for April 12th at 2:45, okay?
Thank you so much.
No problem, and hang tight, we'll get Mr. Rosa in here.
Okay, I appreciate you.
No problem. Okay. Who's Melissa Stover? Do you know what number she's on? Oh, Town? Ms. Reed?
Good afternoon.
Yeah, you're here on the 3:15 with Danielle Evans.
Yes, ma'am.
Okay, don't believe she's appeared yet. Okay, and this is Ms. Honig. You can come up to the table. Mr. McKay, are you there?
Yes, Your Honor.
On the record in the matter of Michigan State Housing Development versus Elsa Honig, file number 22-03504 LTE. Council appearance.
Gregory R. McKay on behalf of the plaintiff, MAC capital KYP 62030.
Today was the date that I reset this matter, and I reset it. I said for the last and final time, Ms. Honig, because you said you had an attorney.
I do.
Where's your attorney?
She is on vacation. I called her the day after I left, the day I left here with you. I spoke with her and told her that we had rescheduled. She's actually been on vacation for about 3 weeks now, and she's not due back to the 4th. I spoke to another associate of hers to ask him if he would represent me. And he had already been scheduled for court at another place, at another.
What's your attorney's name?
Jamie. She's with Wood and Associates. I do know that.
In Lansing?
Yeah. I think
you're saying you already retained this person?
She is the one I have been.
Very
consulting
direct,
with, and she was
very
the one that-
direct question.
Oh, sorry.
Have you retained Wood and Associates to represent you in this matter?
Yeah.
Jamie Rosado?
Yeah, that sounds right.
She's not an attorney.
Well, that's why I've been speaking on.
I'm on Wood and Associates website. They don't have
Is
an
she at a
attorney.
Battle Creek?
They don't have an attorney in that office. I actually was out of Lansing.
Okay, no, I think she's in a Battle Creek office.
What phone number are you using for them?
I have 517-481-3300. I believe that's their switch. That's like the secretary transfers me to.
Hi, this is Judge Simmons calling from 54A District Court. How are you? I'm doing well. I'm in court and I have a person here by the name of Elsa Honig. She has appeared today. She said that she retained counsel from Wood and Associates to represent her, but they're on vacation. I'm calling to confirm that she's retained you. Honig, Hoenig. Elsa, ELSA. You're speaking to Judge Kristen Simmons at 54A District Court. I'm sitting in the middle of a court proceeding and she's here. She said that she retained counsel from your law firm, but they're not here. And I've adjourned this matter multiple times, but specifically adjourned it 3 weeks ago for her attorney to appear today. We don't have an appearance. We've never received an appearance, and she's sitting in my courtroom right now. Well, the representation is that she was retained, not consulted with. Okay, thank you. That's all I needed to know. Not retained counsel. You had a consultation a couple days ago.
Yeah, with the second associate, yes.
But you did not, you did not retain them. You represented to us on multiple occasions that you have an attorney and that you spoke with your attorney about this. And then you told us on the first that you
Right.
wanted to adjourn it because you had already spoken with your attorney. And you wanted your attorney to appear.
Yes.
I reluctantly adjourned it because this matter has been adjourned several times.
Right,
And I told you you needed to appear with an attorney today.
right.
You've not appeared. I just contacted Wood and Associates.
I understand.
They don't have an attorney that works there by the name of Jamie. They have a paralegal by the name of Jamie.
Okay.
But they do not have an attorney there by the name of Jamie. That's in
Okay,
this
I
office
did
on
not know
Battle
she-
Creek.
I didn't know she was a paralegal.
Okay.
I'm sorry.
Okay, and did you, and to retain, did you pay an amount of money to them?
I paid them $100.
Okay, so you did not retain them. That sounds like a consultation fee.
Okay, well, then that was my plan before I was told that she was going on vacation, so I'm sorry about that.
Who was she that was going on vacation?
Jamie, the paralegal. Again, I thought she was a lawyer when I was contacted, and at the very first consultation, that's who they had me speak with. And so that's who I was going to have represent me today.
Okay, well, you're here today without counsel. We've adjourned this matter 1, 2, 3, 4 times already. So there's no more, you've exhausted the adjournments at this point. We're proceeding with your hearing. Mr. McKay?
Yes, Your Honor. This is a summary proceeding for possession, calling a mortgage foreclosure by advertisement. Attached to the complaints are recorded documents or copies of recorded documents have been recorded with the Register of Deeds and indicate a sheriff's sale that took place February the 17th of 2022 involving the subject property, wherein the property was sold at auction to Michigan State Housing Development Authority, my client. There has been more than 6 months since that sale. The redemption period has expired, as indicated on the last page of our evidence on the complaint, the document known as the affidavit of purchaser at foreclosure sale to be recorded with sheriff's deed. The last day to redeem under item 3 indicates last day to redeem is August 18th, 2022. That is, we are far past that date. The defendant is wrongfully holding over after sheriff's sale, and we're requesting that you grant us possession, my client, possession of the subject property.
Thank you. Ms. Honig, do you have any evidence or? Well, let me finish.
No, I'm sorry.
Do you have any evidence or documents that would support why you could lawfully hold over this property after the redemption period?
Yes, there's a couple things I'd like to bring up. First of all, as I came in here originally, back in January, I just received notice. I just received this right before Christmas. I thought I was coming in here again because my half money, the grant money that I was awarded, I thought that's what this was. Okay. I obviously now with continuances and me being here, I realized after I backtracked and did my homework a little bit more on the paperwork that I was given, the date of the sheriff's sale, as per what is in the pamphlet and what I've read online and been told, was that I should have been notified of that. There should have been a posting on my door. Hence, if there had been, because there was nothing on my door, I didn't even know my house had been through a sheriff's sale, I would have easily rectified this whole situation. There were plenty of options for me to save my home in a multitude of ways. Obviously, now this is past. I don't even know what the date is for the redemption period of when it's passed. I think it was passed already once this documentation was served to me when I first appeared in January in front of you.
Yeah, the redemption period had passed when they were served with a summons and complaint, because now they want you to vacate the property.
Right. And that is something that I didn't know about. Was completely in the dark about. And which is unfortunate because now I have my half who I spoke to who really would like to look into this further and can't understand why I'm even in this predicament and knows that I'm in court today, I said, there's probably nothing you guys are gonna be able to do, because now it's too late to try to backtrack, because this is all said and done. I said, but those funds should have been applied as soon as I was granted them. I was granted those in the beginning of February, before the sheriff's sale date.
You were granted my half funds in
Yes.
February of 2022,
Yes,
and you have evidence of that?
yes. There's the letter I got for the grant. I also thought that it was very odd that the very organization that was to assist me in getting caught up on mortgage is now the one that is so gung ho on getting me out of my home. And they also sent me documentation, which happens to be from MISTA themselves, about housing education agencies and foreclosure prevention avenues for me to explore.
Do you have any evidence to support that these funds were applied to your account?
They weren't applied like into my checking account or anything, ma'am. They were directly applied to my mortgage.
I recognize that, but it states here in the documentation, which is you put into the court with a copy or print out of a Gmail email, it appears.
Yeah.
That was sent to you back on February 7th.
That
Well, it says October 18th.
That's when I printed, that off. I had done some, no, that's not right.
October 18th, 2022 at 12:31 p.m. Which would have been after the redemption period, but it says you have been approved to receive my half assistance in the total amount of $25,000. Reading further down, it says, once you return the signed grant agreement, my half will schedule funds to be dispersed directly to each housing provider listed. We recommend that you check with each of them within 7 to 14 days to ensure funds have been applied to your account. If you have any questions, please contact customer service. It says this must be provided within 7 days of receipt of this letter. If documents are not received by October 25th, 2022, your application will be denied. This right here indicates to me that you were granted this after.
No,
But you're talking over me.
Sorry,
This would indicate that you were granted this after the redemption period. I see where it says you submitted an application in February, but they didn't approve this until after the August 2022 redemption date.
There was an attachment to that.
I don't
have it. It went.
I don't have, I just have this. I don't even have evidence that you submitted what they told you to do here, which was return a signed grant agreement. You didn't provide proof of that. You did that. You didn't even provide proof to the court today that within those 14 days, you ensured that funds were applied. But again, what I can see reading this myself is that this wasn't even granted to you until after the sale, after the redemption period.
That is when I requested that to get sent to me, when I spoke to them.
That's not what I see here. What I see here is that they sent this to you in October 2022, which would have been before you were even served with an eviction. And then it says that they needed the documents. They sent this to you on October 18th, 2022. They needed you to get the receipt of this letter within 7 days, and they gave you a date on here.
Yeah.
Which was October 25th. So there's nothing that lets me know that you were granted this amount of money prior to this redemption
I
period.
understand. That was an attachment that wouldn't allow me to print that off. I sent that documentation the very day that they asked for it.
Okay,
But it came up as an error and wouldn't let me print it off. So
right, but
this
you've
is-
had ample time even today to get in contact with them and get a copy of any documents that you wanted to submit to show that you did get this grant prior to the sale, that this money was applied, that you should not have gone through a sale, but you've provided us nothing to date that supports that. We don't have anything. And that document that you're showing me, it doesn't help you, because when I read it, it tells me that you didn't get the money until after the sale and after the redemption period. Do you want to respond to her statement about the posting of the sale on her property?
Yes, if I can call the court's attention to the fourth page of our evidence. There's a sheriff's deeds on page 1. Page 3 is the affidavit of publisher, where it was published, and then page 4 is the evidence of sale, which indicates that a true copy of the notice was attached to the property on January the 19th, 2022.
Okay, and I do have a copy of that, and that should have, it was attached to your summons and complaint, ma'am. It says that on January 19th, 2022. Michael Finney's, I believe, duly swore under oath that he affixed a copy of a publication in a conspicuous place upon the premises described, which is the location of your address, 1105 West Shiawassee, City of Lansing, Ingham County, State of Michigan. So that would address your concern that, or statement that it was not posted. They swore to oath and it was notarized that in fact did take place. Do you have any other evidence or proofs that you would like to present at this time?
This is the notice that I got. This is the conversation I had with my half. And the documentation that she sent me for basically assistance, like I said, the same stuff from Mishta, which I thought was quite ironic that she's given me the documentation from Mishta when I'm actually in court with Mishta to try to save my house. I mean, that's I have a letter from my psychiatric doctor and all the notes and stuff I've been able to do myself, do the legwork. You know, I mean, I feel like this is just not your average run-of-the-mill foreclosure. There's circumstances that if my half or Mishta, since they're one and the same, I just feel like someone dropped the ball. Because I know when I signed that documentation for that grant, I know when I got it, I applied back in January when it first opened up to the public. And so I feel like, yes, I've been thankful and for you being so gracious as to give me continuances. But like I said, when I first walked in here, I didn't realize that I was being told to leave my home. I thought this was gonna be something I could rectify and taken care of. You know, I mean, my half urged me to reach out to legal services of Central Michigan. I've been down to the law office, the law library, to do some research on my own. And I seriously thought that Jamie was a lawyer. I mean, I didn't know she was a paralegal. She spoke to me about all of this. She was the one that even recommended that this was just two paths that didn't cross when they needed to at the very beginning when the funds were released to get me out of arrears. You know, I was being proactive, way ahead of the game. In my mind, in my book, I was. And I thought, good, everything will be, we're good to go. I can get back on track. There's nothing more I want. That's the only thing I have in my life is my house. And it just killed me that I'm sitting here in front of you because I know I can, you know, beg or plead. to Mr. McKay. You know, he's doing his job and I understand that, but you know, if there would be any leniency of any kind, because there's no way humanly possible I could pack and move a house my size by myself in 10 days. There's just no way. I work a 40-hour job. I have an elderly mother that I take care of. And I just don't know how I would lose everything I've worked so hard for in such a short amount of time. And I expressed this to my doctor. He wrote a letter to the court. And just to give you an idea of my state of mind. And I guess I don't know what else to say.
Okay.
Maybe.
Thank you. And Ms. Honig, I want to just be clear. I sympathize with your emotional and mental state, and I recognize this could be very taxing and stressful and gruesome. I mean, this is a home that you own, but the discretion is not within Mr. McKay to give you any leniency. If it were, he would have given you that. He's been here over 5 times on this same matter. And I can guarantee you, if there was anything that he could do, he would have done it at that time. The court is giving you, by way of granting multiple adjournments, even with objections, I would say, from Mr. McKay, giving you additional time. So you'd understand this is coming unless you can provide a reason for the court why you should lawfully withhold this or hold over this property. You've not been able to do that, ma'am. So you've not provided me any legal basis whereby I can allow you to stay in this house. You told me back in February, even before I saw that paper that you gave me today, that might have granted you $25,000 in October. That's what you told, that's what my note said. And so that would have been beyond the time frame for which you could redeem the property. It was already too late if they were granted it in October. And that's where the issue is. They'd already had a sheriff's sale. You already had gone beyond the redemption period. And if anything was going to be done to help salvage, it would have needed to be done during that redemption period, ma'am. So unfortunately, you've not provided me with any legal basis whereby to grant you the relief that you're seeking. I have to grant possession in favor of the plaintiff for the property at this time. Your writ date will be April 10th. That means that if you don't vacate and remove your items from the premises by then, that Mr. McKay's client can come in and seek a writ of execution and then remove you and your items from the property. Do you understand that?
That's Easter weekend.
What does that mean in this Easter weekend? What does that mean?
It just says a holiday weekend.
You have just lost your home.
I know.
And you need to vacate and you're worried about a holiday.
I'm not worried about it. I'm worried more about my family.
Your family, there's nothing I can do. That's by statute. But if Mr. McKay would like to grant you additional time, that's up to him. He can give you that time if his client will allow him. I can't give you any additional time. Mr. McKay?
Your Honor, I'm fine if she has until April 24th, if that will help move this, help her to find movers and whatnot.
Okay, sounds good. April 24th will be the writ date. Okay, ma'am? Do you have any questions? Is that a no? Okay. Any additional matters for the record, counsel?
Your Honor, do you want me to email in a judgment?
Yes, please. You can send it to Judge Simmons courtroom at lansingmi.gov.
Wow. Hold on one second. Judge Simmons courtroom
at lansingmi.gov.
Okay. All right. Thank you. I will have that into you.
Thank you, man. I'm sorry that it worked out for you this way, and good luck to you. Okay. Okay. Is this Ms. Evans?
Thank you, Your Honor. Good luck, ma'am.
Thank you.
You have an attorney.
No. Okay. Okay, and then Mr. Cyber is here.
Yes, ma'am. My manager is here as well from DS Huber.
I see someone by the name of Copeland.
That would be my defendant.
Till, are you representing anybody?
Yes, I am representing Mr. Copeland. I did see that he chatted he put in the chat that his phone is about to die and he will log back on shortly. Can I be placed in a breakout room with him really quick?
Okay, one moment.
Was he with me or with Mr. Copeland?
I'm sorry, with Mr. Copeland.
Okay.
Okay, and then. Anybody here for Christy List or Rodney Wooten? See anybody in the hallway? No one's there? Okay, sounds good. Is there an attorney here on behalf of Hunter Town Properties? Oh, there's that. I'm sorry. Yes. Ms. Reed, we're gonna get Ms. Evans logged in.
All right, thank you.
No problem.
When they're done, we'll just come back in, okay?
Okay, thank you.
Ms. Till's client seems to have logged out. So Mr. Cyber, I'm gonna go ahead and put you and Ms. Till in the meeting room because
Would you
we need to move.
would you add DS Huber with us, please?
No problem.
Thank you.
Yes.
Your Honor, I wonder if you might be able to send my manager into that breakout room with Miss Evans and I. It's Melissa Storball.
No problem.
Okay, thank you. I appreciate it.
Do you know if Mr. Copeland has tried to log back in?
He has not.
Okay, so what I'm gonna try and mute myself and give him a call.
Sounds good. Okay. On the record in the matter of FR Lansing LLC versus Danielle Evans in file number 22-03223 LT, council appearance.
Thank you, Your Honor. Sarah Reed appearing on behalf of the plaintiff.
Thank you, and I have Miss Danielle Evans in the courtroom. She's proceeding without counsel, but you've met today in an attempt to try to resolve this eviction for non-payment of rent. And it looks like my last note indicated that Ms. Evans was approved for some money, but she was trying to coordinate with DHS to get a total payment because your client wouldn't take payment in full. I mean, partial payment, they need payment in full. Is that correct?
Yes, Your Honor, and we've reached an agreement if we might be able to put those terms on the record.
Please do so at this time.
Okay, thank you, Your Honor. Just to clarify, two things real quickly. There is, it's my understanding, $500 in the court's escrow account. Is that correct?
That is correct.
Okay, and at the last hearing, you did set aside the default judgment, correct?
That's correct.
Okay, perfect. All right, so Your Honor, we would enter into a conditional dismissal, and the terms would be that Ms. Evans is going to submit to the plaintiff today the certified funds that she has of $2,700. The $500 from the court's escrow account would be released to Mill Pond as soon as is practicable. And then based on those two payments, Ms. Evans should have the information she needs to provide to DHHS, and Mill Pond will await payment of $870 from DHHS, which would, I think, put Ms. Evans current through at least the end of March. There might be $30 short or over, but it will be very close. And then she'll continue to make her payments timely going forward.
Thank you. That's your understanding, ma'am, of the agreement?
Yes.
Okay. So you understand, ma'am, that you have the right to be represented by counsel during this eviction process?
Yes.
You also understand that you had the right to have a hearing in this matter, which was scheduled for today.
Yes.
Are you willing to waive both your right to counsel and your hearing in order to enter into this conditional dismissal agreement?
Yes.
Okay. You understand that partial performance under this agreement will not satisfy. It has to be total performance as indicated by what was stated by Ms. Reed on the record. You understand that?
Yes, I understand.
Okay, so you're going to submit your certified funds in the amount of $2,700 to the plaintiff. $500, which is held in escrow at the court, will be released to the plaintiff, and then the plaintiff will await further funds from, is that from DHS or for capital area?
DHS.
For DHS. Okay. Do you have any questions at this time?
No, I don't. Thank you.
Okay. Ms. Reed, are you going to get that in writing and submit it to the court?
Yes, Your Honor. I will send that over immediately to Ms. Storball so she can have it ready to be printed and have Ms. Evans sign it when she comes in to make her payment this afternoon.
Okay, sounds good. And any additional matters for the record?
Not for the plaintiff. Thank you.
Any additional matters today, ma'am?
No.
Thank you. You're all set. Thank you.
Thank you.
All right, thank you, Your Honor.
Thank you, Ms. Reed.
Thank you.
Ms. Taylor, are we ready on your matter?
Unfortunately, Your Honor, I have not been able to make contact with Mr. Copeland.
Okay, I can reset this until next week.
All right, all right, I appreciate that, Your Honor.
Yeah, the slot, please. Yeah, we can do it at 9. April 5th at 9:30.
All righty, perfect. Thank you, Your Honor.
No problem. We'll let Mr. Cyber know.
Thank you.